to why this occurred in prison. If somebody steals your stuff and they mouth off, if you don't do something, you become somebody's rhymes with witch. That's why he had to do something. He wasn't trying to break anyone's jaw.
Versus Keontae Colonel. Case number is 25CR42691. Mr. Colonel is present with his attorney, Jim Harden. The state is represented by Brian Goodyear. We are here for a conference. We have a bench trial scheduled April 16. From the prosecutor's perspective, where are we on the case?
Judge, we're ready to proceed to trial. It's my understanding that Mr. Colonel and Mr. Harden may have had a situation where they cannot work together going forward. I believe there's some desire on Mr. Colonel's part to get a new attorney, but from the state's perspective, we're ready to proceed.
Okay. Is it Colonel or Colonel?
Colonel.
Colonel?
Yes, sir.
Okay. Colonel, is there anything you'd like to say?
I didn't pay for the lawyer, but I feel like he worked for me. So if you telling me that you're gonna contact me before court or any other situation that you haven't did, I haven't talked to him. I just been having questions about motions that I want to file, or like where's my discovery? He said he's gonna give me. It's several things that I've been trying to get in contact with him, asking, and every time I talk to him, it's only here. It's only around here where I got to talk in court. And he keep telling me at the end of court, every end of court, I'll be in contact with you. We would talk before court. And every time I call him, he don't answer. My life is on here. My life is on the line here, and I don't feel like he's not caring. He's getting a paycheck. He's doing what he got to do to get this over with.
Okay. Know this, Mr. Harden's a good attorney. The attorneys who are on the public defenders list, I would put him in the top 5. A lot of them are young and inexperienced. I won't say he's not young, but I will say he's experienced. And I've seen him in court, not only here, but 20 years ago he was doing this in the same court where I was prosecutor. So I think you're probably making a mistake, but I'll give you the benefit of the doubt. I just want to let you know, though, that there's only so much an attorney can do. They can't, if they can deal with you on the phone, they will. It's difficult for them because they're on this court-appointed list. It's difficult for them to go out there and sit for 2.5 hours to wait to see somebody. It's difficult to communicate with people. It's just a product of where you are, but you're still entitled to a fair trial. So it's hard to balance all these things.
He can fight. It's no fight. It's like what the prosecutor's saying is going. Under my circumstances of what's going on, I don't feel that I should be still at a felonious assault. Like, I don't want to go to trial because I know of not experience, but of other people's experience going to trial. If I lose, I may get maxed out or whatever. Like, I don't want to do more years than I have to do in prison for this incident. That's a mistake of incident. Like, I'm charged for felonious assault, which we both was fighting. I came from his cell, and then I punched him on the range. It was like it wasn't that he was coming out of the cell just going to lunch or he just an inch, and that's not what the case was. So I just don't want to like lose more time away from my children than I have to.
Okay, Mr. Goodyear, what is the state's perspective of what the evidence will be?
Well, Judge, there are 2 videos that the state would present. One shows a view of the walkway in front of a number of cells, and another shows a view of a stairwell. And in the first video, you see the defendant leave a cell, walk directly up to where the victim is, and the victim is standing, not looking at the defendant. He's facing this stairwell. The defendant comes up behind him and punches him in the face. And that punch makes the victim lose consciousness. The reason I know that is because when you watch the video from the stairwell, you can actually see what you see is basically the floor and then the first bar of like the railing, okay? So you're seeing the very bottom. You see some feet, and you see the victim fall face first and hit his face on the railing. And as he's falling, he's clearly unconscious. And the defendant actually gave a statement to the police where he said he hit him, put him to sleep, and then the guy fell. You've got the videos that show, without any question, that the defendant's the one that caused that to occur. The victim had a broken jaw as a result of that. And we've, of course, got medical records that establish the injuries that he got as a result of the assault. So, frankly, Judge, this is a case I could even try without the victim because I've got it on video, I've got the records. The way I've understood it is Mr. Kernall's belief is that there was something going on, that in the prison system, the victim did something to him that would be justifiable in him reacting to it. I don't know if there is a video that would ever show them doing anything, but if let's say it's a conversation where they're both jawing back and forth. Well, there's no audio. All you would see is two people standing there talking to each other. So I'm not sure that the video he believes could have existed would have been of any benefit to him. But the videos that do exist, without question, establish that he did this.
So we can either appoint a new attorney for you or proceed to the bench trial with the attorney you have, or work out a plea. I don't want to do any more from my perspective as far as plea negotiations because it's probably improper. I don't know if you would tell Mr. Harden what you think is something you could live with. He could at least relay that to the prosecutor. But that's where we are. And if that doesn't get worked out, then we'll proceed with either a bench trial or a jury trial. And that's it. So do you need a minute to talk to your attorney, or do you want to just move forward with a new attorney?
A minute.
I'm sorry?
A minute.
Okay. Morning.
Morning, Your Honor.
This is State of Ohio versus Keontae Colonel, case 25CR42691. We are here today for what is now a plea. According to this, Mr. Colonel plans to plead guilty to felonious assault. That is a felony 2 that carries a maximum prison term of 8 to 12 years, indeterminate sentence, maximum fine of $15,000 with a presumption of prison. There's a joint recommended sentence of 3 years. A determinate minimum sentence of 2 to an indeterminate maximum of 3 on count 1. That's the extent of the agreement. Is that correct, Mr.
Yes, sir.
Goodyear?
It is, Your Honor.
Mr. Colonel, do you understand what you're doing, sir?
Yes, sir.
What is your plea to felonious assault?
Guilty.
I accept your plea. Make a finding of guilty. Anything from the victim on the case?
Judge, we actually attempted, the victim is in a different prison now. We attempted on a number of occasions to get into contact with the victim, and the prison was not facilitating that in any way. But since this is a plea as charged, we just decided to go forward with it.
Okay. Anything from the state beyond the agreement?
No, just we would actually impose the agreed upon sentence consecutive to his current term.
All right. Mr. Harden, anything on behalf of Mr. Colonel?
Thank you. The court's already heard from him in previous occasions as to why this occurred in prison. If somebody steals your stuff and they mouth off, if you don't do something, you become somebody's rhymes with witch. That's why he had to do. He wasn't trying to break anyone's jaw or anything. Does regret that. We're asking the court to go with the recommended sentence and to find him indigent for purposes of any sort of a fine, costs, or anything.
Okay. Mr. Colonel, is there anything you want to say?
No, sir. He said it all.
Okay. The sentence is 2 to 3 years
That's what he has to phrase it.
to be served consecutive to your current sentence. The basis for the consecutive sentence is criminal history and the fact that it's an agreed sentence and a history of criminal conduct demonstrate that the sentence is necessary to protect the public from future crime. Mr. Colonel's conduct has been respectful throughout the proceedings. His fines and costs are waived. You have a right to appeal this sentence. You have 30 days from today to file a notice of appeal. If you cannot afford an attorney will be appointed to represent you. Any document you need will be provided at no cost. Is there anything else I need to cover from the state?
No, Your Honor, thank you.
Mr. Harden,
No, Your Honor, thank you.
do you have any questions, sir?
No, sir.
All right, that's all. Thank you.
Thank you.
Caught in a double shooting in the West End.
Trevor Peters joins us with what we're learning.
Yeah, guys, just in minutes ago from Cincinnati police, officers have arrested a man in a drive-by shooting near I-75. Keontae Colonel has been charged with 2 counts of felonious assault. Police believe the shooting was the result of an argument between Colonel and another person. It happened around 6:30 a.m. on October the 7th. We brought you this story as breaking news that morning. A man and a woman were shot in this car right here in the 1400 block of Western Avenue. Both were taken to UC Medical Center, and both of the victims are expected to be okay. As soon as we learn more, we'll keep following this case and bring it to you here on Air and Online. At the Alert Desk, Trevor Peters, Fox 19 Now.
Trevor, thank you.